proposed.
He say, she say, we say, I say, hearing out them points of views when I see it my way. Yes it goes, yes it knows, maybe so's, probably not, shoulds and coulds.
Hello everyone, this is Spittinfire coming to you with another one. So the government has replied to Mcdavid's motion that he put in on the 31st. Today is September the 1st, and I'm going to read it here on Spittinfire. Now, I've already said that I'm not really great at reading these legal documents and motions, okay? So I don't need you guys to remind me of that shit in the damn thread. Let's get it going. All right, so here it is with the motion that was put in by the government in reply to Mcdavid's, okay? The government replied to the defendant Mcdavid's response to the admission regarding inadmissibility of the purported business record, okay, proposed by defendant Mcdavid. Defendant Darryl Mcdavid response to the government submission regarding inadmissibility purported business records failed to provide an adequate basis for the admission of its proposed Jack Palladino related documents. The proposed document failed every test put set forth by the business record exception Federal Rule of Evidence 8036. Moreover, the government has not, as Mcdavid claims, attempted to use the document in its now concluded case in chief. Argument 1. Mcdavid asserts that the government concedes that the proposed document can be admitted to show their effect on its state of mind. Okay, not so. In its submission, the government explicitly argued that the absent proper foundation demonstrated as to each pre-offered document that he received and reviewed the document and is that effect of his state of mind at the time he assists in recovering video containing child pornography for Kelly. The document should not come in. Mcdavid does not describe in his response the anticipated foundation of the exhibit. Mcdavid merely quips that the government can rest assured Mr. Mcdavid will testify, okay? Rule 302 at 4 and 5. The promise alone does not overcome the insurmountable hearsay obstacles to admission of the documents. Federal Rule of Evidence 8033 allows the introduction of a statement of the declarant and its state of mind, emotion, sensation, and physical condition, such as an intent, plan, motive, design, mental, feeling, pain, and bodily health, but not including a statement of memory or belief to prove the fact remembered or believed. Federal Rule of Evidence 8033. The Seventh Circuit sets out three corresponding requirements for the state of mind exception. The statement must be contemporaneous with the event sought to be proven. 2, it must be shown that the declarant had no chance to reflect, that is, no time to fabricate or misrepresent his thoughts. And 3, the statement must be shown to be relevant in an issue in the case. United States versus Jackson case law. Contemporaneousness, the absence of reflection, and relevance all remain in serious question here. Notably, the hearsay exception depends on the declarant having no chance to reflect upon the perhaps misrepresented his situation. Mcdavid has had some 20 years to reflect this document, rendering some improper for the purpose of the rule. Mcdavid's response also misrepresents the government engagement with the purpose document. Having rest, the government relied on none of Mcdavid's proposed exhibits during his case in chief. Moreover, of the 8 documents that Mcdavid now seeks to introduce, only 1 appear on the government's proposed exhibit list. In other words, there is almost no overlap between what the government considered at one time admitting and what Mcdavid now seeks to admit. When the government subpoenaed Palladino and Sutherland, the record related to, among other things, Charles Freeman in connection with R. Kelly, it did not receive in response the exhibits the defense now proposed, including one that falls within category of the document the government requested. Notably, the majority of the Palladino-related document Mcdavid now seeks to use were not included as a part of the certification the government received with the document produced pursuant to the subpoena. The government saw the majority of Mcdavid's proposed exhibits for the first time when Mcdavid proposed them as never agreed that they are business records. To that very point, and in contrast to Mcdavid's assertions, the government declined to use these documents at trial precisely because they cannot be valid as business records. And as noted, Rule 299 at 5, the witness Mcdavid plans to rely on its validate these documents as business record pursuant to Federal Rule of Evidence 8036 will only be able to testify that they appear to be records of the company. Given the pervasive issue allowing the admission of the proposed document risks an inconsistent approach to the admission of evidence, Mcdavid and other defendants objected on hearsay grounds to the admission of the notes of a polygraph witness taken at real time in the course of regular conduct business activity. Okay, in addition to moving to introduce the document, the government did not move to admit at least 50 other exhibits on its proposed list. Okay, see trial, whatever this. Although these notes fell within the scope of the hearsay exception for present sense of impressions, Federal Rule of Evidence 8031, they were excluded on relevance grounds and for the purported prejudicial effect on the jury. In keeping with the ruling, exclusion should also occur with regard to the proposed document. Mcdavid did not prepare the document in question, and even if he read them, this recollection has had some 20 years to either stagnate or significantly shift for the purpose of the state of mind exception. Ultimately, while Mcdavid may testify about these documents, that is far different than admitting such wide range of potentially prejudicial document in an evidence. The government requests the court to review the proposed Mcdavid document in a camera before ruling on their inadmissibility. 2. Conclusion. For the foregoing reason, the United States respectfully requests that the court exclude the pre-offered document for admission into evidence at trial. Respectfully, John Larsh, Jr. And that is it for that note. All right, thank y'all for tuning in to Spittin' Fire. I just wanted to come up to read you my horrible government response. And in the meantime, in between time, I did not even put in a watermark, so you can go back and read this shit the best that you could if I didn't read it good enough for you. All right, take care. Fire out.